A very important aspect of Indian Constitution is Legislature of Union and States. Let us look into the legislative functions of the Union and States. We all know that India is a parliamentary democracy. The preamble of the Indian Constitution says India is a sovereign, socialist, secular, democratic republic country. The Constitution of India is the supreme law of the land. Article 1 of the Constitution says India, that is Bharat, shall be a union of states. This has a very significant aspect in the Indian Constitution. India is a union of states. So that itself shows that there is legislative for the state and legislature for the center. India is the largest democracy in the world and it is most populous democratic state. And we all know that the democracy in India has been there from the independence. Let us look into the preamble. The preamble states, we the people of India have resolved to constitute India into sovereign, socialist, secular, democratic republic. Now, it is very important that we have sovereign status in the international aspect. India is a socialist country as a matter of principle, secular also as a matter of principle. It has democratic values, conducting free and fair elections in a timely manner, and republic means the head of the state is elected by the government and not a monarchy. It to secure to all its citizens. It provides justice of social, economic and political, liberty of thought, expression, faith, belief and worship. It also provides equality of status and opportunities in many areas and promote among them all the fraternity of the individual, the dignity of the individual. Now, unity and integrity of the nation also assumes a very important position that India, though is union of states, none of the union shall have the power to secede from the mainland. India is a powerful federation of states. So we, on the 26th day of November 1949, this constitution was adopted to the country. Now, let us look into the significance of the preamble in the constitution as to how the legislature becomes more prominent because of the preamble. Now, in the 42nd Amendment in 1976, the word socialist was inserted by the 42nd Amendment. Because India is a welfare state, socialist was made a principle policy by the government. The Constitution also states that it is a secular state. As like any other country, India does not have a state religion. It does not follow any religion as a state religion. It respects and promotes every religion prevalent in the country. The provisions of secular and socialist, though was not provided in the initial constitution in 1949, it was amended and inserted in 42nd Amendment. So thus, all the words of the preamble aids as an interpretation to the constitution. Preamble is considered to be the preface of the constitution. It contains the ideals and principles of the constitution. Now we all know that the preamble provides a interface between the different functionaries of the constitution like legislature, executive and judiciary. Whenever there has to be any interpretation, the various Supreme Courts have resorted to the various decisions of the Supreme Court have resorted to the preamble for its interpretation. The preamble reflects the purpose and objectives that the constitution is sought to achieve. For example, though the word socialist was not present, it was inherent in the principle of the executive and legislature. It was inserted by the 42nd Amendment. So whenever the policy has to be made, the socialist principles has to be adopted by the government. The directive principles of the state policy had already mentioned the principles of socialist in its lawmaking. Now, the Supreme Court in its judgment said that preamble is the most precious part of the constitution. It is the soul of the constitution and key to the constitution. It is a jewel set in the constitution. It shows the importance of preamble in the constitution in interpretation and understanding. In a very important case of Berubari Union in 1960, in a presidential reference under Article 143 Clause 1, which was on the implementation of the Indo-Pakistan Agreement related to Berubari Union. Article 3 of the Constitution gives power to the Parliament to secede or to give any part of the country to a foreign territory. Through this case, the court says that the preamble is key to open the mind of the makers. Now, in a very significant ruling, the Supreme Court said that preamble was not a part of the Constitution, but it can only help in interpretation of the Constitution. Though this observation was later changed by an important case called the Keshwananda Bharati case in 1973. In this case, the Supreme Court held that preamble is part of the Constitution. It is a source of power to understand the Constitution, and thus it deviated from the Berubari Union case, stating that it is a very important part of the Constitution and it is one of the basic structure of the Constitution. Now, in the preamble, when we look into the word democratic setup, a free and fair election is a very important necessity. Now, universal adult franchise is adopted by the government, where it says, the citizen of India who is an adult having an age of 18 has the right to vote by means of free and fair elections. The general elections to the central government and to the state government is held once in every 5 years. Now, the responsibility of holding and conducting the elections is under the Election Commission of India. The term of Lok Sabha or the Vidhana Sabha is for 5 years, unless dissolved earlier for many other reasons. Now, here people send their representatives through elections, through direct, which is to the Lok Sabha, or through indirect, which is to the Rajya Sabha. They send their representatives to the Parliament. Both Lok Sabha and Rajya Sabha constitute the Parliament. These members of Parliament represent the people. They are the voice of the people. Now, universal adult franchise means any citizen of India who has attained the year of 18, irrespective of his caste, creed, sex, gender, race or ethnicity, have the power to right to cast the vote, unless he is disqualified by the legislation, which will be dealt in detail. But by the 61st Amendment Act of 1988, the Parliament lowered the voting age of citizens of India. Before it was 21 years, later it was amended and made to 18 years, thereby making the participation in electoral politics more inclusive in nature and then including more of youngsters to be participant in the democratic process. India follows a parliamentary democracy. Now, we all know that after the independence, most of the provisions was the Constitution made most of the provisions from the Government of India Act of 1935. We followed the system of parliamentary democracy, which the United Kingdom was following for many years. Now, parliamentary democracy means a system of democratic governance where Parliament is responsible to the people. Legislature is directly responsible to the people through a system called election. Now, India governs on the principle of republic form of government, where the citizen choose their representative. Now, republic means the head of the government, that is the president, is not a monarch or a king or is a authority by inheritance. He is elected by the people through an indirect method called principal representation by means of single transferable vote. So, the Parliament is the highest law-making body in India. Now, what are the features of the parliamentary democracy in India? Now, President is the nominal executive and Prime Minister is the real executive. This is also followed in the parliamentary democracy of United Kingdom. Here, President becomes the nominal executive but has many constitutional powers, but the real executive is the Prime Minister. Article 74 provides for the Council of Ministers headed by the Prime Minister, who aids and advises the President in its functions. So, aids and advice becomes a very important function for the executive. This is also called a majority party rule. Whoever gets the majority, whichever party or the coalition of the party secures a majority seats in the Lok Sabha, forms the government. The other ministers in the Parliament by the executive are appointed by the President on the advice of the Prime Minister. This is another important philosophy is called collective responsibility, the Prime Minister and the Council of Ministers are collectively responsible for the Parliament. The ministers, who is an executive, should also be part of the legislature. Now, this is another important deviation from the strict principle of separation of powers. The separation of powers says that there shall be a strict separation between legislature, executive and judiciary. But in Indian parliamentary democracy, there is separation of powers between executive and judiciary, but there is no strict separation of powers between legislature and the executive, because whoever is a minister should primarily be a member of the parliament, either Lok Sabha or Rajya Sabha. Ministers are the members of the parliament, and the members who are elected to the parliament only can become the ministers. The president dissolves the Lok Sabha on the recommendation of the prime minister. So in principle, the executive has the power to dissolve the legislature. Another important aspect of India's model of parliamentary democracy is executive is responsible to the legislature. The ministers are responsible to the legislature. They are answerable to the legislature. They are answerable to the questions posed in the legislature. Even though Indian Parliament is based on the British model, India has a republican system where the president is elected. The Great Britain has a monarchy. We all know that the United Kingdom has unwritten constitution, but India has a lengthiest written constitution in the world. Let us now look into the difference between Indian system and the British system. Though both the countries have republic, India has a republic, but the United Kingdom has monarchy. India chose the system of republic system of government, where the head is not a monarch, but he is elected by the people. Unlike the limited role of monarch, the President of India has many responsibilities. The written constitution in India specifies the roles and responsibilities of the President. Now, it says that all the power and authority of the Supreme Independent India, the Sovereign Independent India, shall vest in the head of the state, who is the President of India. Now, under the United Kingdom, the monarchy reigns, but he does not rule. The unelected monarch is the head of the nation. He is in a representative role for the sovereign acts of the elected government. His main functions includes to appoint the Prime Minister, so as well as in the Indian Constitution, and all other ministers. He can open and address the new sessions of Parliament. He gives royal assent to the bills passed by the Parliament, signifying that they all have become the law. Now, after the independence in 1947, India became the member of the Commonwealth. Commonwealth is a voluntary association of the former colonies of the United Kingdom. They are all, after independence, they become the members but are the sovereign nations. They are mere associations. Looking into Article 1 of the Constitution, it gives us a clear picture of what kind of democracy India has. India has a federalism, also called as quasi-federalism. The national government is responsible for the broader governance of the nation, while the states are autonomous, having powers to rule the respective provisions in the state. Both the national government, state and the center have the power to make law. The states have certain level of autonomy and independence in certain areas from each other. But significantly, the national government enjoys certain strong centralizing powers over the local government. And that is the specific reason why India inserted the word shall be the union of state. The Indian form of federalism is called the quasi-federalism because India has a strong central government. For example, the United States of India has the federal government, but the states government have greater autonomy than the central government. But the framers of the Indian Constitution adopted another version of the federalism where the union government and state government have the powers to make law in their own spheres of administration, but significantly the central government has the edge over, or it has more advantage over lawmaking powers due to the centralizing tendencies or the centralizing characteristics of the Union of States, and that is why it is called quasi-federalism. What are the important centralizing characteristics of the Constitution? Because India was formed as a federation after the princely states came into the sovereignty of the central government, the physical integrity was considered to be absolute, and therefore the states have no right to secede from the Union. Indian Constitution has what is called asymmetrical federalism, which means that India has the unitary state with the federal characters. In a very important observation, in the words of Sir Ivor Jennings, he says India is a federation with a strong centralizing characters.